Hello, I'm Rachel Jones from Legal Services Vermont, and with me is George Sammons. We would like to first thank the American College of Bankruptcy Foundation for supporting this video series. In this third video in our series, we will be discussing the aftermath of filing a Chapter 7 bankruptcy. So I'm going to hand it off to George to ask our first question.
Great, thanks, Rachel. So what happens at the end of a bankruptcy case?
Good question. So when the bankruptcy case is completed, the filer's debts are discharged. So this means that the filer is no longer legally obligated to pay that debt. Also, the discharge is permanent, so a collection agency or a creditor can't try to collect on that debt after it's been discharged through bankruptcy. Now, keep in mind that only debts listed on the bankruptcy petition can actually be discharged. Some debts, such as child support obligations or debts resulting from criminal acts or other types of debts, cannot be discharged at all. So it is really best to speak with a bankruptcy attorney if you have questions about discharging individual debts, as the bankruptcy attorney will be able to assess your specific situation.
Great, thanks. And so I know a lot of folks calling in about bankruptcy are, particularly concerned about how it might affect their credit score afterwards. So how does bankruptcy affect your credit report?
Good question. So many people are understandably concerned about how a bankruptcy can affect somebody's credit, as well as their future ability to obtain credit or loans. And so after a person goes through bankruptcy, the bankruptcy will stay on the credit report for 10 years. And also the 10-year duration starts at the bankruptcy's filing date, not the date of the discharge. And in many cases, delinquent debts have already harmed a filer's credit score in the first place. So the actual effect of bankruptcy on a person's credit report can vary quite a bit. And also future loan prospects can vary depending on the lender and the type of loan. Now, some loans, including conventional mortgage loans, may be more difficult to obtain after filing bankruptcy. Bankruptcy filers may need to wait 1, 2, maybe 3 or 4 years before qualifying for a conventional mortgage loan. But however, if you establish good credit after filing, you will be in a better position to qualify for a conventional mortgage loan. And also lenders are primarily concerned with current financial standing more so than with past financial standing. Also, a bankruptcy appears on when a bankruptcy appears on a person's credit report, the outstanding debt will read as zero as long as the debts have been discharged. And future creditors will know that a person can only file a Chapter 7 bankruptcy once every 8 years. Many creditors are more interested in the debts currently owed rather than the ones that have been discharged already. So in some cases, filing bankruptcy may actually make it easier for a person to obtain new credit because the debt balance would be listed as zero. And then once debts have been discharged through bankruptcy, it is really important to check your credit report for any errors. So as long as debts have been successfully discharged, they should read as zero. And an error on a person's credit report can affect the person's credit rating, and the consumer should dispute any errors that come up. So just to dispute an error that you see, you will need to write to the reporting company or companies such as TransUnion, Equifax, or Experian. And also a sample dispute letter and the addresses of credit reporting companies can be found on the Consumer Financial Protection Bureau's website.
Great, thanks. And I think you touched on it briefly, but I just want to circle back. So how often can you file a Chapter 7 bankruptcy?
Good question. So a consumer can file a Chapter 7 bankruptcy once every 8 years. But in order to calculate this waiting period, keep in mind you will need to go off the previous bankruptcy's filing date, not the discharge date.
That makes sense. So next question is, can bankruptcy affect future employment?
In many cases, bankruptcy will not affect future job prospects. Bankruptcy is a federal right, and government agencies, for example, are not permitted to discriminate against a person for filing bankruptcy in the past. That said, some private employers in select fields may view bankruptcy as evidence of financial problems. And this could include jobs that deal with money, such as accounting or payroll positions. So it really depends on the type of job and the company, and what you're looking at. But that said, bankruptcy may also get rid of some consequences that could affect employment. For instance, bankruptcy could eliminate wage garnishment or burdensome collection calls, if those have been taking place before the bankruptcy case was filed. And the elimination of collection actions may actually make it easier to maintain a steady income. So again, the effects on employment can vary, from person to person and case to case.
Great, thanks. And so you mentioned burdensome collection calls. So how can I avoid predatory lenders after filing a bankruptcy?
Mhm. So, since a person can only file a Chapter 7 bankruptcy once every 8 years, some lenders may see bankruptcy as an opportunity to extend credit. Some bankruptcy filers are also surprised to learn that lenders may advertise to recent bankruptcy filers. But recent filers should be very wary. They should be wary of credit offers that are specifically directed to recent bankruptcy filers. For example, if the credit offers say, we are advertising to bankruptcy filers, that should be, something to look out for. These may come with high fees or less than optimal terms. So always read the fine print for any sort of credit offers that you may get. Um, borrowers should also be cautious if an offer is made from a company whose debt was recently discharged in that bankruptcy. Some companies may make offers to transfer the balance from the discharged debt to the new account. In other words, attempting to reaffirm the debt that was already discharged in the bankruptcy. So, when in doubt, always read the fine print, and do not agree to any offer that will likely cause significant financial problems down the road.
Great, thanks. That's really helpful. Um, so do I still owe secured debts such as car loans after bankruptcy?
Good question. So, if you reaffirm a secure debt, such as a car loan, you will still be obligated to make payments after the bankruptcy case is complete. In return, a reaffirmation agreement could allow you to keep a piece of property, such as a vehicle, if you remain current on that loan. Now, the reaffirmation agreement must be approved by the bankruptcy court. Reaffirmation is optimal or optional. You don't have to agree to reaffirm a debt if the creditor pressures you to. Um, it may be beneficial for certain secured debts, and these are debts that involve a piece of property or collateral, such as a vehicle, if you want to keep the property after the bankruptcy case is complete. Now, if your debt is discharged in the bankruptcy case, you will no longer have a legal obligation to pay that debt. However, the lender may still have an interest in the property that is connected to the loan, such as commonly a vehicle. If you don't stay current on payments, the car lender may repossess the vehicle, after the bankruptcy case is complete, but staying current on car payments will prevent repossession.
Thanks. So the bankruptcy is complete. I've discharged some debts, and now I want to figure out how to rebuild. How can I improve my credit and financial standing after bankruptcy?
Good question. So there are various ways. For example, budgeting is a good place to start. To create a simple budget, you should gather your bills, pay stubs, and recent bank statements, and various financial documents that you might have. From there, you can map your monthly income expenses and see where adjustments can be made if possible. If you are struggling with your bills, don't wait to reach out to your creditors, to see if they are willing to adjust any bill payment plans. It's always a good idea to reach out as soon as possible if problems come up. You should also look through your credit report to make sure there are no errors. As we discussed before, errors on your credit report can affect your credit negatively, and they should be disputed if you find any. You can check your credit report for free for visiting annualcreditreport.com. And that is a great, place to start, to look at, your financial standing. Also be wary of credit offers that target people who are struggling financially. For example, if a creditor advertises a plan with no credit history required, or maybe a credit offer is specifically aimed at recent bankruptcy filers, the offer may be pretty risky. And really the last thing you would want is to get deeper into a debt because, say, a credit plan has high fees or other risky elements. And really don't accept a credit offer simply because you want to build new credit. Make sure you read the fine print and only accept reasonable terms that won't harm you financially. You could look into secured credit cards, but again, make sure the deal is reasonable. And also be wary of scams or predatory companies that advertise quick fixes. If a company sounds too good to be true, it may be. Fixing credit can take a lot of time, and quick fixes aren't always honest. Now, while mistakes can be disputed, credit repair companies cannot remove accurate information on your credit report. Some predatory credit repair companies will demand payments before taking action, or maybe they'll tell you to dispute information that is actually correct and accurate. So again, just be very wary of any company that reaches out to you that promises quick fixes or instant credit repair. Now, bankruptcy cases will stay on your report, as we discussed, for 10 years, and past derogatory marks will stay on your report for 7 years. So even if past delinquencies still remain on your credit report, your credit standing will improve over time if you maintain stability as best you can. Bankruptcy may help with employment stability. For instance, wages may no longer be garnished after the case is complete and after you get that discharge. So again, the focus is the long run, trying to get in a stable position and slowly building your credit.
Excellent. Thanks so much. And so lastly, what should I do if a creditor tries to collect a debt that has been discharged in bankruptcy?
Good question. So, as long as the debt has been successfully discharged, the discharge is permanent and collection actions must cease. So, if you receive collection letters, for example, regarding a debt that has already been discharged and you know it has been discharged in the case, the first step is to remind the collection agency or creditor about the bankruptcy in writing. If collection efforts are continued, a bankruptcy filer could file a motion to report the collection action and reopen the bankruptcy case. Now, a creditor may be sanctioned by the bankruptcy court if the discharge order is violated. So again, keep an open eye if you hear back from creditors where the debts have already been discharged. So thank you so much for tuning into this third video. Again, we want to thank the American College of Bankruptcy Foundation for supporting this video series.